network. So we stopped at a closing phase of a negotiation agreement, the closing phase. I remember I said, in spite of the fact that we have come to the closing phase of any negotiation, it still does not mean that we cannot start all over again, depending on the situation and the communication laxities that could make it so. So from today, we will go on to negotiation as a tool in conflict management and resolution. Negotiation, a tool in conflict management and resolution. It is imperative to assert that negotiation is the base for all forms of conflict resolution. It is imperative to assert that negotiation is the base for all forms of conflict resolution. What does this mean? It simply means that in all the areas of ADRs, in all the ADR mechanisms that we have, negotiation is the first step, the base for all of them. Because you cannot mediate to negotiate. You negotiate to mediate. You also negotiate to conciliate. You negotiate to arbitrate. There must be negotiation before you go to mediation. And the reason why I opted to begin this lecture with negotiation rather than mediation, so that we can flow along that line. So that we can flow along that line. Now, over the years, and even in our present world, negotiation has shown itself as a viable tool in the management and resolution of conflict. Perhaps we need to, enumerate some examples that will serve as evidence to the truth of the above assertion. I am going to give us a very succinct example that some of us are very conversant with. The apartheid administration of the South Africa before 1991. I'll talk about the protest against injustice. On March 21, 1960, I'm giving a sense of what negotiation can do to bring about peaceful resolution of issues. So I'm using the case study of African Sharpeville incident of March 21, 1960, in the township of Sharpeville, South Africa. Police opened fire on a large but peaceful protest, putting and wounding scores of unarmed demonstrators. The day marked a very particular tragic event in a long, bitter struggle against social oppression. On the anniversary of this massacre, 25 years after, police again opened fire once again, killing a more unarmed protester. With this macabre replay of history, townships across South Africa erupted in a wave of desperation. Like the generation before them, these desperate men and women were protesting apartheid. There's nothing in anybody protesting a government policy that seems, on only to them. A brutal, comprehensive system that, through a range of notorious laws and practices, including the Mixed Marriage Act, the Group Areas Act, the Bantu Education Act, and the Job Reservation Act, was designed to enforce racial privilege. You see, all of these enactments, all of these laws were enacted by the then South African government, to create a divide, as it were, between a segregation, the white and the black. So, what is the crime of these peaceful protesters? By 1986, in a determined attempt to hold on, the South African government declared a national state of emergency and launched a bloody beatdown. Tens of thousands of youths were detained without trial, and many were tortured and killed. In response, the mass democratic movement, representing over 7,000 organizations and 2 million individuals, called for general insurrection. The nation teared on the edge of civil war. Yet, in an extraordinary example of far-sighted statesmanship, South African President, then President F.W. de Klerk, and the African National Congress, ANC leader Nelson Mandela, found ways to negotiate their vast differences and curb the violence engulfing the nation. In 1990, with security costs out of control and the economy in a tailspin, the Klerk surprised the world with his decision to release Mandela on Robben Island, where the grainy leader had languished for 27 years. In their first face-to-face negotiation, the Klerk agreed to lift the state of emergency, while Mandela committed the ANC to restrain its supporters and help curb the nation's violence. In their next encounter, the ANC agreed to suspend its armed struggle, while the government agreed to release political prisoners and allow political exiles to return to the country. You can see, this is a system of negotiation. On the one hand, the government, released Mandela from prison. On the other hand, Mandela negotiated that. Hello, sir. Please let us unmute. Hello, let us unmute so that we can. I'm giving a scenario of negotiation from the South African angle. So please let us listen very carefully. The discussion will not be helpful to us. In their next encounter, I said, the ANC agreed to suspend its armed struggle, while the government agreed to release political prisoners and allow political exiles to return to the country. By December of 1991, the government and the ANC held the first convention. You see, the government of South Africa then, under WBF de Klerk, and the ANC, the South African National Congress, held the first convention together for a democratic South Africa named CODESA, which included parties and stakeholders from across the country. Their mission to negotiate a new constitution. You can see, to negotiate a new constitution, one that will protect and empower all citizens and to prepare the divided nation for its first multiracial election. The rest has become history. We know what came after that negotiation. South Africa became a peaceful and developed nation immediately after that election. Also, let us look at the Cold War period. The Cold War period. The Cold War period between 1994 and 1945 and 1991 was regarded as an era when the world was close to witnessing a nuclear war. The United States of America and the Union of Soviet Socialist Republic, the USSR, were held to be the major rivals during this period, as a lot of conflict arose between these superpowers. Among these conflicts, the Berlin crisis of 1958 to 1962 and the Cuban Missiles Crisis of 1962 are worthy of recognition based on the role negotiation in managing and resolving it brought about. Hello, can I continue?
Yes, sir. Please, you can go ahead.
Okay. The very contentious issue surrounding the Berlin crisis was that the Western powers, that is Britain, America, and France, constituting the Berlin Group, were in violation of the Potsdam Agreement, thereby losing their rights to the Berlin. Thus, the Soviets demanded the withdrawal of the Western powers by advancing ultimatums. The then premier of USSR, Nikita Khrushchev of the Soviet Union, wanted to bury the United States as well as make USSR the global superpower in the world. In addition, his first interest was to remove the Allied force from Berlin and spread communism to the western part of the world, thereby preventing the domination of Europe through their western countries and their capitalist movement. However, the White, Eisenhower, and John Kennedy maintained their position on never to give up Western Berlin to the Soviet, as well as preventing the communism epidemic. There was a standoff between the United States of America and the Soviet Union. Now, what happened? Negotiation was used to manage the Berlin crisis rather than to resolve it in a destructive manner. Rather than use a destructive manner, they used negotiation. And what did they use? They used what we call the constructive approach, the win-win approach, the integrative approach. That was what they used. They used the integrative approach to bring about the face-off between the United States of America and the Soviet Union and their allies. The integrative model in negotiating was employed as a strategy in resolving this conflict. It was unanimously agreed on the October 27, 28, 1962, that the United States of America will put to an end to its interference in Cuba and withdraw its digital in Turkey. On the other hand, the Soviets agreed to dismantle its missiles in Cuba and end its interference in Turkey. This was a win-win situation as both countries retained their national honor and strength without losing face. You can see what negotiation did. Rather than, engage in conflict, rather than go to war, they decided to use the win-win approach rather than use the win-lose approach. If both parties had gone to war, it would have been more destructive to the nation, to the world, because the beginning of the war is what we will see. We don't know what the end will be. Taking account of another case was what happened in 2012, the Chicago Teachers Strike. Rahm Emanuel, former chief of staff to President Barack Obama, took steps that alienated Chicago school teachers, such as rescinding a promise to pay for a pay rise and lobbying the Illinois state legislature for an education reform that limited the issues the target teachers were asking for or could negotiate and strike over. A failed contract negotiation resulted into a 10-day strike, which drew the nation's attention to issues facing educators, school districts, and students. They eventually reached an agreement that managed the conflict between the teachers and the government, such as annual raise to teachers, lengthening the school days, and allowing teachers to be evaluated in part with students' test scores. In addition, all laid-off teachers with strong rating were guided into a new job, leaving the international scene. There is an ongoing religious conflict in Nigeria, which has metamorphosed into terrorism. A terrorist organization situated in the northeast of Nigeria, known as Boko Haram, has been held responsible for the kidnapping of over 276 secondary school girls at Chibok in Borno State, and numerous bombings in the northern region and other parts of the country. Their main ideology, which was Western education, to be abolished. That's the meaning of Boko Haram. Said education, Western education is sinful, is haram, which led to the killings of thousands in Nigeria. The most recent is the kidnapping, as aforementioned, which happened on the 14th to 15th of April 2014. This incident has attracted international debate, and we all know the story of the Chibok girls. We all know the story, and we all know what it has come to. But we know how some of these girls today have been, released. Some have been released. Some have been regained their freedom. Some have been reunited to their parents because government refused to engage the kidnappers, these Boko Haram terrorists, in the face of the government preferred, even though some of us believe that government should not have negotiated with them. You don't negotiate with criminals. We see them as criminals. But they are fighting a cause. They are fighting for a cause. The cause may be just to them. It may be unjust to us, but they are fighting a cause. And government has been good enough not to engage them in the fiscal that will endanger the lives of these children. In conclusion, conflict is a gas of thought. It stirs us to the observation and memory. It instigates intervention. It shocks us out of sheep-like passivity and sets us at nothing and contriving. Conflict is a sine qua non of reflection and ingenuity. Conflict and human beings are inseparable. Apparently, conflict will cease to exist only when rapture is upon us. You see, that means from the beginning of creation, conflict had existed. And until creation is no more, conflict will remain. So, why do we run away from conflict? We rather face conflict and manage conflict and resolve conflict. That is what that statement is telling us. That is what it is telling us. But be that as it may, conflict has its positive and negative effect. But the important thing is devising a means for either managing or resolving or doing both, unless there will be no development in every ramification. Negotiation has come to both manage and resolve our conflicts, rather than doing it through the rigorous proceedings of our courts. In recent years, negotiation has proved itself as a viable tool in dispute resolution and conflict management, thereby making our world habitable irrespective of our differences in ideas, values, beliefs, and background. The apparent situation is we negotiate to mediate, we negotiate to conciliate, we negotiate to arbitrate. In all the ADR processes, negotiation is baba. Negotiation is first. So it is good to negotiate rather than, litigate. So we say negotiate rather than litigate. Thank you, and God bless. Institute of Global Peace and Conflict Management. Thank you. God bless you.
Thank you, sir. We deeply appreciate you.
Thank you very much. Thank you. We will go into mediation immediately. Mediation.
Okay, sir.
Probably, I'll give you 2 minutes to be able to readjust your slides. Are we ready?
Sir, concerning the slides for the mediation, I don't know if the registrar spoke to you, but it's actually not available.
On the mediation process, are discussed. Now, I would attempt to go into the keywords. Let's go into the keywords. The keyword here is mediation, international conflict, escalation of violence, mediation techniques, success stories, international relations, and peacekeeping. And like I said, I will not bore us with the details of it. The Institute will provide the slide and provide the course materials in the process of putting together all of these things. So please, so that we don't waste much of our time tonight. Mediation as a mechanism for resolving international conflict is becoming increasingly important. It is a process of intervention by a neutral third party who helps the parties to conflict to find common understanding and agreement through dialogue and negotiation. Mediation seeks to create an atmosphere of trust in which conflicting parties can express their interests and concerns and seek compromise options that satisfy both sides. Let me give you a typical example of what mediation is like. In my course of career as a lawyer, I handled a manslaughter case. A very prominent Nigerian, I won't mention his name, a very prominent Nigerian ran into a young school leaver, a young graduate, that finished his NYC and was looking for a job. The guy fell from a moving moonway. This was back in 1997, I believe, 1997. 1993. My wife just reminded me it was in 1993. It was in 1993. The guy fell from a moving bus. And this prominent Nigerian, I said, coming from his own vehicle, rammed on him on the express. Meanwhile, the more we ran away, the more we didn't stop. Despite the fact that passengers in the motorway were telling him, stop. He didn't stop. He just went away. So the unfortunate man coming and rammed into him, eventually killed the young man. This man, the prominent man, picked him up, took him to the hospital to see whether he can be revived and taken care of. He actually took good care of him. Eventually, before the boy got to the hospital, he passed on. And you know what that means? Whether it was accident or not, it's manslaughter. And the police will have to be called in. They brought in the police. The police arrested my client, and he was detained. 4 or 5 days after, the family of the young man came and said they were going to court. Incidentally, the family of this young man are Muslims, very fundamental Muslims. I'll use that word, fundamental Muslims, because they are very chronic Muslims. Whereas this man, the accused person now, the suspect now, is a Christian. So the police waded in, charged the matter to court. In the process of charging the matter to court, the family of this man engaged me. And what did I do? I told them, allow me to handle it the way best possible for us to find a lasting solution, a peaceful solution. And they said, lawyer, whatever you do, just go ahead and do it. So I adopted a style of empathizing first with the deceased family. I kept on going to every day to plead with them, to give them succor, to pray with them, to give them, words of encouragement. I do this every day. I'll go to the house. I'll go to greet the parents in their mosque. They have a mosque very close to the house. So I go to them to plead and to, talk to them with, somebody who felt their loss. Anytime I go there with some members of the man in detention, now in Kirikiri. He has been arraigned in court. The court had asked him to be remanded in prison pending the DPP report. So we were going there to see the family of the deceased. Each time I go there, I tell the family of the man in prison, do whatever you see me do. Anything you see me do, that's what you do. I will go there. Before I enter into the house, I will remove my shoe. Remove my socks, put my socks in my shoe, and I'll go there. I'll sit on the floor with them. I'll sit on the floor and try to talk to them. Give them sermons. I sermonize to them and tell them it is the will of God and this and that. Another time, I'll go to them in the mosque. I'll remove my shoe. And this was what I was doing for a very long time. And the court session was still going on. Each time the court was adjourned, they will come to court. Furious. They want to take a pound of flesh. But when they realize the way I had been coming to them persistently, and each time I go to them, I submit to their culture. I submit to their, to their religion. I come, not showing that it was an accident. No, we empathize with them, and all of just these things, touch the hearts of the family of the deceased. And on the next date of adjournment, before the DPP's advice came, the family came with a very senior lawyer, and they announced that the family is no longer interested in pursuing any child against the suspect, and that they believe that it is an act of God, and that they believe also that he didn't do it deliberately, that in fact from the totality of the reports they got, that he was just an unfortunate man, because he was not the one that killed the man. The man would have died anyhow if, having fallen from a moving motor bus. And that was how they withdrew the matter from court. And by the time the DPP came, it was just like a fait accompli for us. The DPP report just said the man had no case to answer. Why am I saying this? I am saying this because I want us to know the effect of, empathizing in situations that we find ourselves to mediate, particularly as mediators. We'll come to some of this. I've just given this example for us to be able to, move on to the next page. Now, mediation is a conflict resolution process in which an independent third party, the mediator, helps the parties reach a mutually beneficial solution. The mediator does not take sides in the conflict, but acts as a neutral facilitator, promoting dialogue and mutual understanding. Mediation, according to Hopkins, is a conflict resolution process in which an independent party called a mediator helps the parties to a conflict to reach a mutually acceptable agreement. The mediator acts as a facilitator, facilitating communication and dialogue between the parties and helping them find compromises and solutions that are in their best interest. Mediation, like I said earlier, can be domestic. We have domestic mediation and we have international mediation. Mediation is widely used in the resolution of international conflicts. In such conflicts, the parties involved may be states, international organizations, ethnic or religious groups. Mediation helps prevent the escalation of violence, reduces tension, and promotes peaceful resolution. You see, we mediate because we don't want crisis. If we want parties to solve themselves, out, they may not be able to do that effectively, and that will result into, a crisis that may generate into a blown up, war. But with a mediator as a third party, the mediator brings his skills, his technical know-how into that crisis and provide solutions and guide the parties. Of course, the mediator has to be neutral. Of course, the mediator's role is to just, guide them and ensure that none of them held on to any particular positions rigidly. So therefore, mediation is a conflict resolution process in which an independent party called the mediator helps parties to a conflict to reach a mutually acceptable agreement. Mediation in international conflict is based on the principles of fairness, respect, and trust. Parties must be able to trust the mediator. Parties must be able to have absolute respect for the mediators. The mediator earns that respect. He does not beg for it because he must earn it. And how does he earn it? He must earn it through his involvement. He must not be partial. He must not be seen to be on the side of one party against another. So that's when he can be respected by the parties and he can be trusted. The mediator does not take sides or impose his or her own solution, but helps the parties to find a mutually acceptable agreement, taking into account their interests and needs and ensuring the sustainability of the resulting solution. One of the advantages of mediation in international conflict resolution is its flexibility and ability to adapt to different contexts. Mediators can use various methods, such as facilitating dialogue, applying legal norms, and creating platforms for discussion to promote harmony and reduce tension between the parties. In international relations, mediation plays an important role in resolving conflicts between states, international organizations, and other actors. Who are these actors? The actors are organizations and individuals who are not members of government or state institutions, but who influence processes in the society and international relations. Non-state actors include, for example, non-governmental organizations, trade unions, business and media representatives, experts, etc. They can play an important role in conflict resolution and problem solving within their area of expertise. Non-state actors can also contribute to the formation of public policy and exert pressure on government in favor of certain groups or to achieve specific goals. So, the important role of mediation in international conflicts is its ability to empower the parties to make their own decisions and control the outcome. The mediator can provide information and expert opinion, but the final decision is made by the parties. In mediation, the role of the mediator is to provide information, to provide expert opinion, but the final decision lies in the hands of the parties. The parties have the final say, and that is why mediation is a better option to litigation in all ways, because the parties are directly involved. They are involved in the decision and in the process that brought about that decision for resolution. The basic principles of international mediation in the context of international relations include: one, neutrality and impartiality. Neutrality and impartiality. What is neutrality and impartiality? The mediator must be neutral and impartial towards the parties to the conflict to ensure the trust and respect of the parties. Number two, voluntariness. Voluntariness. Mediation is voluntary. Parties cannot be compelled to come to mediation. Parties cannot be coerced to come to mediation. So it is voluntary. Participation in mediation should be voluntary, and the parties should have the right to terminate the mediation process at any time. Whenever a party felt that is no longer comfortable with the mediation process, it has the right to opt out. And that is why it is parties cannot be coerced, parties cannot be compelled voluntarily. And at any point in time, parties can opt out of that mediation. Number three, confidentiality. Confidentiality. Confidentiality means the mediator should ensure the confidentiality of the mediation process and protection of information exchange between the parties. The mediator is not in a position to divulge information derived in the process of mediation to anybody, without the knowledge of the parties. For instance, I, as a mediator, mediating between two parties, whatever information I got from party A must be confidential to me and party A. Whatever information I got from party B must be confidential to me and party B. I cannot disclose what I have, the privileged information I have with party A to party B. Neither can I disclose the information I got from party B to party A, unless it is the agreement of the parties that I disclose this. Number 4, flexibility. Flexibility. Mediation must be flexible to accommodate the unique needs and interests of the parties to the conflict. Flexibility. Mediation must be flexible. It should not be rigid. Litigation is rigid. You know, you file a paper, there will be counter affidavit, further affidavit, you know, future affidavit, tomorrow affidavit. Yet, you know, it's so complex, so complicated. It's funny. Yeah, that is the complexity of our legal system. That is the complexity of the legal process. And that is why most people now opt for ADR, because ADR allows them to flex. It allows them to flex. They can, you know, yes, they have option for this, option for that, unlike the litigation. Number 5, fairness and equity. Fairness and equity. The mediator must ensure that both parties have an equal opportunity to express their interests and that the decision resulting from the mediation is fair and satisfactory to all. Somebody is distracting us. Somebody is distracting us. Somebody is distracting us. Fairness and equity. The mediator must ensure that the time allowed for party A is also the time allowed for party B. Party B must not have an edge above party A. Party A must not have an edge above party B. Party B. There must be fairness and there must be equity. Everybody must be treated equally. That is the one of the importance of mediation. Then, lastly, respect for cultural and religious differences. Respect for cultural and religious differences. The mediator should take into account cultural and religious differences between the parties to ensure a more effective mediation process. What does that mean? Take, for instance, party A is a woman in Buddha. Party B is a nun, a Christian nun. And party B, who is a Christian nun, demands to see the face of the woman in Buddha. And the woman in Buddha says, no, you can't see my face because my religion does not permit you or permit me to open my face in public. I can only open my face when I'm in my husband's, enclave. And party B says, no, you must open your face. The mediator must be able to educate the parties that here, religion is respected, culture is respected, values are respected, and norms are respected. So, every culture of every individual party, every religion of every individual party, every custom of every individual party must be respected by either of the parties, and must be ensured that no party overruns the other in their cultural or religious differences. There are several approaches to mediation in international relations, which may differ depending on the goals, interests, and abilities of the mediator, as well as the nature of the conflict and the cultural context. Some of the most common approaches are facilitation approach. The mediator allows the parties to openly communicate and find common ground, but does not offer concrete solution or force an agreement. The facilitator, that is the mediator, must allow open communication. In fact, in mediation, aside from the mediator, there are no other parties. There is no fourth party. There is no fourth party. It is the parties, and the third party is the mediator. However, the mediators can be more than one. The mediators can be more than one. But there will be no other party aside from the mediator and the parties. So, to allow for open communication between these parties, so the mediator must facilitate that openness in the mediation process. Transformative approach. The mediator seeks not only to resolve a specific conflict, but also to change the relationship between the parties that led to the conflict. You see, something brought about the conflict that has brought about a divide between the parties. Aside from the mediator finding a solution to the conflict, the mediator must be able to bring about a transformative relationship between the parties, so that where they were before they came into that mediation, they would have, been reconciled, they would have been reunited, they would have been realigned to one another. So, by the time they left the mediation table, they become friends. They are no longer enemies. They are no longer adversaries. Because in the first place, that is the reason why they came to mediation, so that they can become friends after resolving their conflicts. 3, result-oriented approach. What is the result-oriented approach? The result-oriented approach is when the mediator focuses on achieving a specific outcome, such as signing a peace agreement or concluding a trade deal. You see, mediation is not successful until there is a specific outcome from that mediation. And what is that specific outcome? The signing of a peaceful agreement, the signing of an agreement that reunites and bring about a win-win situation for parties. Number 5, or is that number 4? Number 4. Multiple or cultural adaptive approach. The mediator takes into account cultural differences and adapts his or her mediation style to the cultural context of the parties. I told you the story of the accidents that happened and how I mediated and was able to resolve the conflict without much ado. Then multiple mediation. What is multiple mediation? It's when a mediator may conduct a series of mediations to make incremental progress towards conflict resolution. Multiple mediation, it jumps from one mediation to another. It is the same mediation process, but it becomes multiple because there are multiple parties involved. A mediator conducts a series of mediation to make incremental progress towards conflict resolution. I want to, go straight to the conclusion because I'm getting exhausted. I don't have lights here, and I hope the Institute will do us the good by sending this paper out to everybody to have. In conclusion, let me just conclude so that we don't waste much time. I'm getting stuck here. Mediation is in international conflict resolution. I'm on conclusion now.
Yes, sir.
I'm on conclusion now, please. Yes.
Go ahead.
Yes. Mediation in international conflict resolution plays an important role in resolving international conflicts by providing parties with an opportunity for dialogue and compromise solutions. It helps to prevent conflict escalation and reach a peaceful agreement. Mediation in international conflict resolution plays an important role in achieving peaceful resolution and international conflict. This paper shows that mediation helps to establish dialogue, find compromises, and prevent conflict escalation. However, the effectiveness of mediation depends on factors such as the availability of an independent mediator and the support of the international community. Despite this, mediation faces limitations such as mistrust and political differences between the parties. Further development of mediation requires the improvement of mediation methods and training of mediators, as well as creation of norms and institutional mechanisms to support mediation in international politics. Overall, the paper confirms the importance of mediation in international conflict resolution and calls for further research and development in this field. The effectiveness of mediation depends on several factors, including the ability of an independent and neutral mediator, the support of the international community, including states and international organizations, and the willingness of the conflicting parties to actively participate in the mediation process. However, mediation also faces a number of constraints and challenges. This includes mistrust and aversion between conflicting parties, strong political differences, and complex historical circumstances. In addition, mediation can be weakened if conflicting parties do not adhere to the principles of good faith and cooperation. On this note, permit me to rest this paper today. I hope I have been able to meet your yearning. Thank you for giving me the opportunity to speak to our distinguished audience.
So it's time for questions.
Well,
Yes,
sir.
yes. I'm ready.
I'm happy. Stated that everything about mediation that was very confidential.
Yes.
Mediation was very, very confidential. Now, a situation where after a mediation has been agreed and signed, then one of the parties in future, either for political reasons or a new government, whoever decides to go for litigation, and then the mediator is near to come and give evidence. But he not, when that case is litigated, not give evidence by disclosing some of the decisions that was made between between him and party A, and between him and party B. And you talked about confidentiality.
Thank you very much. You see, when an agreement has been reached, when there is a consensus between parties in mediation and an agreement has been signed. When we started this lecture, I am supposed to inform our August audience that there is a law in Nigeria today by the name Mediation and Arbitration and Mediation Act. Arbitration and Mediation Act 2023. This act expressly, I'm yet to go through it, extensively, so I can't quote the section now. This act expressly, provided that once a mediation agreement is reached, it is binding on parties. Where a party in the future now feels that he is no longer going to be bound by that agreement and he goes to court, the court will just rely on the mediation agreement that was reached at that mediation, process. However, if there be a need for the mediator to be called upon to give evidence, the mediator will go and give evidence based on the agreement that he has a copy of. He will not be compelled to disclose anything because already that agreement that was reached at that mediation table supersedes any other thing. It is binding on parties, and parties can no longer come back and say he's no longer bound by it. It is just for the court to adopt the decision of the mediation proceedings. So parties can no longer come and say they are no longer bound by the decision of the mediation. And however, where it becomes necessary for the mediator to disclose any privileged information, he will be doing it because the law compels him to do it, and he will not have done any wrong. He will not have violated any law because he's giving it under oath and he's compelled by the law to do it.
Hello, sir. I have a question.
Yes, sir. Yes, sir.
Yeah, from your explanation,
yes.
I believe, yes, when a mediation is closed, that is at the closure, yes, the mediator has the right to keep the information away from the public, especially parties that are involved. But
to keep the information away from the public?
From those who are not involved.
Yes, yes.
Now,
yes.
What I'm looking at is a situation whereby the closure in the mediation process, and eventually,
yes,
after reached an agreement which is considered to be the final stage of the mediation, whereby parties now adopt the. What happens if new facts emerge that were not
when new facts emerge?
Yes, sir.
This is breaking. You said what happens when new facts emerge?
New facts that were not considered in the process. A party did not disclose all the information.
Then, in that wise, what the court will do by the act, by that mediation act, what the court will do is refer back the matter to mediation, and it can be started de novo. You know, I said we can start de novo. It doesn't matter whether we have come to a closing agreement. We can start de novo. As it is in negotiation, so it is also in mediation. What the court will just do is, order the parties to return back to mediation. However, where at that point in time, parties now say they are not going back to mediation, they want to litigate, then file your papers.
Which means in that instance, the mediation has failed.
Yeah, exactly.
Exactly.
Yeah. Exactly. Yes. Thank you. Mediation fails sometimes. Does.
Thank you very much, sir.
Is somebody asking a question?
Yes, sir.
Yes,
sir. Can you hear me, sir?
I can't hear you. That's why I'm asking. Yes, sir. Please, I'm with you. Sir. Yes, sir. I'm with you, sir.
Okay. It's raining.
Please let's have
can we have
Mrs. Grace
the lady
ask her question?
Yes. Can we have the lady? She asked first.
Yeah. Good evening, everybody.
Good evening, ma.
Good evening, ma.
Hello.
We are with you, ma. You can go ahead with your question.
Please, okay. My question is, in the case of national mediation international this time around, we had an agreement between two communities, and then at the end of the day, another fact emerged, just like it emerged in international, and then the two communities disagreed. Does it mean that the mediation is no longer valid, the previous one? That there's a fresh crisis again?
If a fresh fact emerged, I didn't hear your question very well, ma'am.
The questions are
yes.
What if there was a previous mediation and there was the two
there have been an agreement in the previous mediation.
Were signatory to it and they agreed to.
Can somebody help me?
But
Mrs. Grace, we can't get you. I think your network is bad. So just put down your question in the chat. We'll get it from the chat.
It's ready here.
Okay, ma, we understand. Please put in your question in the chat. We'll get it from there. Please, the next person can ask.
Yes, the next question, please.
Okay, good evening, sir.
Yeah, that's Mr. Solomon Apofure.
Yes, sir. Thank you very much for the insightful lecture. Really appreciate it.
Thank you very much.
I want to ask two questions from the scenario you gave as regards your client that tried to be a good Samaritan and the whole thing was turning out to be something else. But thank God for the way you intervened. Now, my first question is, we that are non-lawyers, can we handle such case? That's number one. Then number two, if we find ourselves in such position and we find a victim like that, what should we do? What do you advise we do?
Yeah, thank you very much, sir.
Yes, sir.
We are all human beings. We are all human beings. I'm going to answer that question from the human angle. By the grace of God, I know your fears. I have experienced this many times in my life, and it has not deterred me from doing what I should do as a human being. Okay. Yes, we come across situations that will demand our humanity.
But because of the attendant problems, because of the issues that may arise thereafter that may not be palatable to our lives and our future, we tend to look the other way. I will cite the example of the Good Samaritan. I'll cite the example of the Good Samaritan. We all know the story of the Good Samaritan and how a priest who ordinarily should be the one to give a helping hand, saw the man who needs help and just, bypassed him and said, "You're on your own," Then come several people before the poor Samaritan came, took him on his ass to a nearby hospital, paid for the rent, and paid for his upbringing and his health to be restored. We need not exercise any fear when we know that what we want to do is to help humanity. What I usually advise people to do, is when you pick an accident victim, for instance, when you pick an accident victim, it doesn't matter. Let us assume that you are not the one that knocked him down. You saw him on the road and you don't want him to die. The first thing is take him out from where he will be further damaged or mutilated beyond, recognition. Take him away from the road, if he's on the road, put him on the curb. Having done that, call attention of one or two people to give you a hand. Tell them you are just, a good Samaritan, as it were. People may want to come to your aid to assist you. I have done it before, but people will say it's because I'm a lawyer. Well, I don't need to be a lawyer to help somebody. I do it without counting cost, without counting the consequence to my life. I've done it severally, like I said to you. So, what you do is pick up the accident victim, take him or her to the nearest hospital, give your information. If the guy or the victim can give his information, let him give his information. Reach out to his people. If he's still able to speak by the time he gets to the hospital, good for you. But if by getting to the hospital, he passed on, it is still good. Providence will, make you, mark you right that you have done the needful for humanity. But you see, people fear that police will come and detain them. Yes, it has happened. And people have suffered very, very bitterly over issues like this. There are so many people in prison today for offenses they never committed, just because they are trying to help. But what can we do? Will we, because we don't want to go to prison, not attend to what we need to do as humans? You see, what I usually think for myself is, what if this person is my relation? I don't want to bore you. I would have told you a story of my personal self. My wife is a living witness of this event. But it's a long story. Eventually, it bounds back to us that the lady we gave assistance to, she was going to have a child. The car carried her to Ayike Hospital, broke down on Bank Anthony Way. And we saw her bleeding. And I said to my wife, we are coming from Eko Hospital to see a neighbor who was sick then. And we ran into this lady bleeding. The car taking her to Ayike Hospital to deliver broke down. The car was, almost catching fire. So the parked the car off the road, and she was there, written in pain. So I just told my wife, I said, if we carry this girl now, I mean, this woman now, it will be another trouble. But my wife said, let's carry her. Let's go. And we now went to turn from county hospital. We turned from county hospital and headed back again to where we found her. We picked her in our car and took her straight to Ainke Hospital. We didn't leave Ainke Hospital until 2 a.m. from 7 p.m. in the evening. Incidentally, the guy who was standing by the car was the husband. I got to know about this later. They borrowed the car that they were taking to Ainke Hospital when the cars accidentally caught fire on the road. And in order not to run into Bese, the husband said, let me put this fire off. So we didn't know. We just picked the car and took her to the hospital. Eventually, this lady became the niece of one of my youthful friend, my bosom friend, myself and the uncle were in Rotary Club together, the same Rotary Club. Eventually, this girl gave birth in my presence. In fact, I personally took the delivery of the baby after she had been delivered in the ward, and tagged the baby Kilani. That's the name of the family. I tagged her baby Kilani, and thereafter, they found us out. I didn't give my contact, but they found us out because I had made certain, commitment to the hospital. So from the hospital, they found us out and they came to look for us. And on the day of the naming of this child, I found out that this girl and myself are families. You see, if I had left her and she had bled to death, and I found out that she died, and my friend will now tell me, she lost a niece who was going to have a child on so date, and she died, and I would say, do you think I will be able to say I saw her? I will not be able to say I saw her. My conscience will not be able to say I saw her, because I cannot say I saw her and I abandoned her. Being a Rotarian, being a lawyer, it doesn't matter who I am, but it is the humanity in me that has done that. So, in a short, humanity demands from us what law would not require from us. And if you choose between humanity and law, I will choose humanity, because law is made for man, not man for law. Hello?
Mr. Solomon, please respond.
Yes, sir. In fact, thank you very much, sir. You answered me very well. Thank you very much, sir.
Yes, sir.
And God bless you for the role you have played. I pray God to give us the grace for each and every one of us to do that also.
Amen.
Amen.
Thank you, sir.
Thank you, sir. So we have the question from Mrs. Grace. It's currently in the chat, so I'll read it out so you can respond to it.
Yes.
So she says, what happens if the previous mediation between two communities becomes void due to fresh crisis after about 9 months?
Becomes void.
Yes, sir.
Can never be void. Can never be voided. An agreement reached. The only authority that can void a mediation agreement is the court. Is the court. Is only a court that can void a mediation agreement. We will need to go and get acquainted with the Mediation Act, the Arbitration and Mediation Act 2023. It's only a court of competent jurisdiction that can void a mediation agreement. A mediation agreement cannot be voided by any of the parties. If new facts emerged, and those facts are facts that has to do with the issues of the mediated agreement, then parties can now approach the court.
parties can approach the court. The court will interpret those facts and see whether it can void that previous mediation agreement. But for parties that have agreed into, an agreement, jointly consented to, what a mediation agreement means before the court is it is referred to as consent judgment. It is referred to as consent judgment because it is an agreement between both of you. You both agree to it, and once you bring it before the court, you enroll it before the court endorsed it, and it becomes binding on both of you. So it is the court that can void it, and you must approach the court for its interpretation.
Thank you, sir. Mrs. Grace, hope your question was answered. Are there any other questions? Okay.
I think you can close the page.
Okay, so there are no more questions, sir.
No more questions?
Yes.
Thank you very much for giving me, sir. Thank you. Thank you.
Thank you, sir.
Opportunity from you.
Thank you very much. Thank you for the interesting lecture. Thank you for the interesting lecture.
Thank you, sir. Thank you very much.
Thank you, sir, for the lecture.